Every company has an internal rule book, right? But what happens when those private rules crash into what the outside world expects? Well, today we are diving deep into the legal ideas that control how a company works on the inside and how it deals with people on the outside. We'll look at what you really need to know before you ever sign a contract with one. Let's get right into it.
So, here's our roadmap. First, we're going to peek inside the company and check out its private rulebook. Then, we'll see how that document stacks up against its public-facing constitution. After that, we'll flip the script and look at things from your perspective, as an outsider. We'll cover the pretty strict responsibilities the law puts on you, but also the crucial legal shield that protects you. And finally, we'll find out when that shield can break.
All right, let's kick things off with Section 1, the internal rulebook. This is really the nuts and bolts of how a company runs day to day, and it has a formal name, the Articles of Association, or just the AOA. The most important thing to get here is that the AOA is basically the company's operating manual. Seriously, it's the how-to guide for just about everything, from how they appoint directors and run meetings to how they issue new shares. It manages all the internal machinery and spells out who has the power to do what.
This old quote from Lord Cairns just nails it. He says the articles are subsidiary to another document, the memorandum. And that word is key. The AOA doesn't set out the company's big, grand purpose. Instead, it takes that purpose and builds the step-by-step framework for how they're going to achieve it. It's all about the execution.
So this brings us to a really important comparison. To get a handle on the AOA, you have to see it next to that other big document, the Memorandum of Association, or MOA. And the easiest way to think about it is like this. If the AOA is the company's rulebook, then the MOA is its constitution. Okay, this table really breaks it all down for us. Let's start with objectives. The MOA defines what the company is supposed to do, its whole reason for being. The AOA then explains how they're going to do it. Then, for relationship, the MOA faces outward. It defines the company for the rest of the world. The AOA, on the other hand, faces inward. It's all about managing internal business. Now, what about changing them? Well, altering the MOA is a huge deal, kind of like trying to amend a constitution. The AOA is way more flexible. And this last one is the biggie, scope. If a company does something that goes beyond the powers in its MOA, that act is completely void, period. But if they just break a rule in the AOA, well, that can often be fixed and approved by the shareholders later on.
All right, so now we get the internal documents. But what in the world does this mean for you, an outsider who wants to do business with a company? This is where the law introduces a very important and, frankly, kind of harsh rule. It's called the Doctrine of Constructive Notice. And here's the deal. Because a company's MOA and AOA are public documents, the law assumes you have read them. And not just read them, but that you've understood them. It doesn't matter if you actually have or not. The law basically says, hey, the information was there. It's on you.
So the logic goes like this. 1, these documents are public record. 2, because they're public, you are legally presumed to know what's in them. And 3, that means you can't sign a contract that goes against the company's MOA and then turn around and claim you had no idea. Ignorance is no excuse. If the deal is beyond the company's powers, it's your loss.
But wait a minute. This creates a huge problem, doesn't it? Okay, fine. You can read the public AOA. But how could you possibly know if the company actually followed its own internal rules for a specific decision? I mean, did the board hold the right meeting? Did they get enough votes? It's impossible for an outsider to check on that stuff.
And that's precisely why the law created a counterbalance. This is an absolutely critical protection for outsiders, and it's known as the Doctrine of Indoor Management.
You might also hear it called the Turquand Rule. And what it says is, look, while you're expected to know what's in the public documents, you are not responsible for being a detective and policing the company's internal affairs. You get to assume that all those internal procedures, the meetings, the resolutions, the approvals, have all been handled correctly.
The famous case that gave this rule its name, Royal British Bank versus Turquand, illustrates this perfectly. So a company's articles said its directors could borrow money, but only if they passed a specific internal resolution. They went and got a loan from a bank, but they never actually passed that resolution properly. When the company couldn't pay the loan back, it tried to get out of it by saying the directors didn't have the authority. But the court sided with the bank, saying the bank had every right to assume that all the internal paperwork was in order. And the court's ruling established this really powerful and simple principle. The company's indoor affairs are the company's problem. outsiders aren't expected to peek behind the curtain. As long as a deal looks legitimate on its face, you're protected.
But, and this is a big but, this protection is not a blank check. The law is always about balance. And there are some very specific situations where you, the outsider, actually lose the protection of this doctrine. So let's look at when that powerful shield can fail. There are three main exceptions we need to talk about. First, if you actually knew there was an internal problem. Second, if the whole deal was so suspicious that it should have raised some major red flags. And third, in cases of outright forgery. Let's start with knowledge. This one's pretty simple. You can't claim you assumed everything was fine if you actually knew it wasn't. In the Howard versus Patton Ivory case, some directors lent money to their own company. But here's the thing. They knew perfectly well they hadn't gotten the shareholder approval they were required to get. So they couldn't turn around and use the Turquand Rule to protect their investment because they were aware of the problem from the get-go.
Okay, the second exception is suspicion. The law does not protect you if you choose to ignore obvious warning signs. If a deal is strange enough to make you think, that's weird, you have a duty to ask some questions. In one classic case, a person bought company property from the company's accountant. The court said, come on, that's obviously suspicious. Accountants don't normally have the power to sell off company assets, and because the buyer didn't bother to investigate, they lost the rule's protection.
And finally, forgery. This one is an absolute deal breaker. The Doctrine of Indoor Management can protect you from internal mistakes, procedural slip-ups, that sort of thing, but it cannot magically make a forged document valid. A forgery is a total nullity. It's void from the very beginning. In the Rubin case, a company secretary forged directors' signatures on a share certificate. The court's ruling was simple. The certificate was worthless, and the rule offered zero protection.
So let's do a quick recap of everything we've covered. The AOA is the company's internal rulebook, and it operates within the bigger framework of the MOA, which is its constitution. The Doctrine of Constructive Notice says it's on you to know what's in those public documents, but the Doctrine of Indoor Management protects you from having to worry about a company's secret internal processes, unless, of course, you knew there was a problem, the deal was super suspicious, or forgery was involved.
And that brings us to our final thoughts. This whole legal setup is a really delicate balancing act, isn't it? On one side, you have the need to protect companies from people acting without authority. On the other, you have to protect innocent outsiders who are just trying to do business in good faith. So the question is, how does this constant push and pull really shape modern business, from tiny startup deals all the way up to massive corporate mergers? It's something to think about. Thanks for joining me.